Good afternoon and welcome to the MIT Alumni Career Lunch and Learn webinar series. My name is Ellen Stahl and I am the MIT Alumni Career Counselor who will serve as host and moderator for today's workshop. Our webinar is being broadcasted live and we'll be collecting questions from you throughout the presentation. Please type your questions in the chat box on the lower right-hand side of the WebEx window. Your questions that you type will not be seen by the audience and will only be seen by me, so confidentiality can be respected. A few technical notes. We have over 300 people on our online audience today, but again, for your privacy, you cannot see the other attendees. Also, please know you are all muted and can only ask questions via the chat box provided. If you can see the presenter right now but cannot hear the audio, try using your phone to dial into the audio portion. I'm posting that dial-in information now in the chat box on your screen. Our presentation today is, don't worry about that non-comp agreement and other lies the internet tells you. This webinar is scheduled from 12 o'clock to 1 o'clock. We will hear from our presenter until about 12:35-ish, at which time we will open our Q&A portion of the program. Please type your questions in the chat box at any time during the webinar. You do not need to wait until the Q&A segment. Before we get started, I want to introduce you to our presenter today. We are extremely fortunate to have with us as our content expert, Boston-based attorney Evan Fray-Witzer. Evan is a founding partner of Fray-Witzer, an employment, defense, and complex business litigation boutique firm. For more than 20 years, Evan has maintained an active employment litigation, counseling, and defense practice focusing on discrimination defense, non-competition, non-disclosure, and non-solicitation agreements, wage and hour claims, commission claims, and other employment-related litigation. Evan also provides sexual harassment and other employment-related training and is regularly retained to conduct internal investigations. Evan also maintains an active national complex business litigation practice with cases in the federal district and appeals courts across the country. Evan has an active copyright litigation practice focusing on issues arising under the Digital Millennium Copyright Act and also routinely handles litigation matters involving partnership disputes, breach of fiduciary duty claims, trade secret and confidentiality cases, and internet defamation claims. Evan, welcome, and thank you for sharing your expertise with us today. I hand it over to you.
You know, Ellen asked me if I wanted to do a PowerPoint presentation, and I'm pretty anti-PowerPoint, and I think I might be starting to reconsider that about now. But what I want to do first is go through essentially a little bit of a general overview of non-competition law and then move into some of the more specifics of what I think people might be interested in. So as a notation first, you need to understand that non-comp law, like most of employment law, is state-specific. And so although I can speak to generalities with respect to non-competition agreements, from state to state there are variations. The most obvious variation is California. California does not believe in non-competition agreements. California won't enforce non-competition agreements. Companies cannot have non-competition agreements with their California employees because the courts of California simply won't enforce them. So if you've dialed in for this seminar from California, I suggest you spend the next 45 minutes watching old David Bowie videos because the simple truth is non-comps aren't enforceable in California. If you are anywhere other than California, though, the general rule is that non-competition agreements are enforceable, but they have limitations to them. And the limitations, for the most part, are somewhat similar from state to state, though, as I've said, they do have some variations in a variety of states. But what I'm about to tell you is pretty much the general rule. And so the general rule is that non-competition agreements are enforceable, but what's often considered to be enforceable but disfavored, which is an odd way of putting it, but it basically means that the courts are not necessarily going to enforce the agreements to the extent that they are written, but they're going to put certain limitations on them. One of the limitations that you will see pretty much no matter where you are is that the non-competition agreement needs to be reasonable in the amount of time, the duration of the agreement. And although, again, there are variations from state to state and variations factually, what a lot of courts will say is I've never seen a court that says a 6-month non-comp is unenforceable. I've rarely seen a court say that a 1-year non-competition agreement is unenforceable. You start to run into questions around 2 years, though here in Massachusetts, New York, and a lot of other places, 2-year non-competition agreements have been found to be enforceable. The upper end of the spectrum is 5 years, and those tend only to be enforceable under some really specific circumstances that we'll talk about later. So the first limitation on non-competition agreements and their enforceability is the duration of the agreement. The next limitation is based on the geographic limitations, although quite honestly, geographic limitations in some industries, in a lot of industries, have started to fall by the wayside. And the reason for that is the Internet. If you are operating a business that is international in scope now, your non-comp agreement may well be an international non-comp. If you're still in the kind of local brick-and-mortar business where geographic location is really important, then you're going to see the geographic limitation requirements still be enforced. A lot of times people who have regional sales focus, for example, will have a non-competition agreement that is limited to the region in which they have been operating. And depending on the specifics of what someone is doing, the geographic limitations can be the country, the region, the state, or within a certain number of miles of where they operate, depending on really where businesses pull their business. So,
Evan, I have one question for you. Just for a good question from the audience. People are wondering, what's the definition of a non-comp for today's conversation?
Okay, that is a great question. And so the starting idea is that a non-competition agreement is any kind of agreement that says to an employee after they leave the employment from one employer that for some given period of time that they cannot, and it's usually you cannot directly or indirectly, work for or provide services to any competing business. And we'll talk a little bit about what that means a little bit later, but I'll tell you as a general rule, although the companies, and I write non-competition agreements for companies all the time, although we try and make them really incredibly broad, the idea and the way that they generally get enforced by the courts is a bit narrower. And the idea is you cannot be doing for a direct competitor those kind of things that you did for your first employer. And so that's what we're talking about when we talk about non-competition, although there are there's some variations to the theme as well. Non-solicitation agreements are often part of non-competition agreements or a separate entity, and non-disclosure agreements are similarly in that category. Non-solicitation is pretty much what it sounds like. You're not supposed to be soliciting clients or customers that you had worked with in the first business, and non-disclosure is simply a limitation on your ability to use confidential or proprietary information, although those concepts also get wrapped up into non-competition agreements. So hopefully that answers the question, and if it doesn't answer the question, please send another chat message and we'll try and do that. So again, we've talked about two of the general limitations on non-competition agreements, but then you enter into an area where there is a limitation despite the way that the agreements are written. Most courts in most states say that they will only enforce non-competition agreements to the extent that they are designed to protect a legitimate business interest. And the definition of that is really sort of interesting, because what the court says, look, we're not going to enforce non-competition agreements simply because you want to keep someone off the market. That's not the idea. The idea is not that you are allowed to squelch ordinary competition through the use of a non-competition agreement. And instead, what you are supposed to be doing with a non-competition agreement is protecting one of two major categories. First of all, confidential or proprietary information of the business. So if, for example, by going to a new employer, you would by necessity be using the confidential and proprietary information from the first employer, that's an area in which the courts will say, yeah, this is a reason to enforce a non-competition agreement. Now, I want to be clear, because companies all the time, and I all the time when I'm operating for the companies, will try and make confidential and proprietary information sound much broader than it really is. It is not simply that you have gained a specific skill by working for an employer. A general skill or knowledge that you could gain by Googling or by doing some really extensive research, that's not confidential or proprietary information. Confidential or proprietary information is limited to those kind of things that you could not have learned outside of working for this particular employer. Sales forecasts, customer information, details about upcoming products, details about what customers are looking for in a particular market or what they're upset about with a particular product, pricing models, client lists, those kind of things are generally found to be confidential and proprietary information. The second area of legitimate business interest is corporate goodwill. And the idea behind that concept is when you have an employee, and very often it's in the sales context, who visits with customers and who is the point of contact with clients, that person develops a certain amount of goodwill with the client. Well, the idea is that that goodwill, although it is being developed by the employee, really in essence belongs to the employer. They're the ones who are paying the person's salary. They're the ones who are paying for the relationship to be developed. And if the employee was allowed to simply move to a new competitor and take that goodwill with them, the new employer would be gaining some sort of unfair advantage. And so that is another area in which the courts will enforce non-competition agreements. So those are the general ideas, and with that in mind, what I want to go to next is some reasons why non-competition agreements may be more enforceable than you have been led to believe. And in particular, if you've done your research exclusively on the internet, where you can find websites all the time that say, oh, non-competition agreements, they're really not enforceable. And as a general rule, that is simply not true. But there are, as I've said, some reasons why they're more enforceable than you think. One idea that people seem to have very frequently is, I signed my non-competition agreement a long time ago, 5 years ago, 10 years ago. It can't possibly still be enforceable against me. And whenever I get a client who comes to me and says that, I like to say to him, do you own a house? Do you have a mortgage? Did you sign the mortgage with the bank a long time ago? Do you think it's not enforceable anymore simply because you signed your mortgage agreement with the bank 10 years ago? Just like any other contract, the non-competition agreement remains enforceable even though it was signed a long time ago. Very often I hear from people, well, the non-competition agreement can't possibly be enforceable because it would prevent me from doing the thing that I've done for my entire career. It's an understandable argument, and it's an argument that the courts have rejected pretty uniformly, because if that argument were to carry the day, it would mean that non-competition agreements were largely unenforceable all the time. People very often think that if they were fired from their job, that necessarily means that their non-competition agreement is not enforceable. And that, too, is not precisely true. There are instances in which being fired may make a non-competition agreement unenforceable, but it's definitely not a blanket rule. If you are terminated because the company doesn't have the business to employ you, that might be a reason that the non-competition agreement becomes unenforceable. But if you are terminated for cause, it does not make your non-competition agreement unenforceable. And I like to say to people, well, you know, if someone's fired for stealing from the company, a great reason to be fired, why would that possibly void out your non-competition agreement? The courts are not going to reward essentially bad behavior by excusing you from your non-competition agreement. Another reason that non-competition agreements become even more enforceable than ordinary is if the non-competition agreement is not simply in connection with your employment with a company, but if you are in the position where you have sold a business, and as part of the sale of the business, you have given a non-competition agreement, those agreements get enforced much more strictly than the purely employment non-competition agreements. The length of the time can be a lot greater. That's where you see the 5-year terms being enforced, if they're ever enforced. And the courts are much more stringent about non-competition agreements that accompany a sale of a business. And the idea is the reason that you got your purchase price, the price that you got for whatever the sale of your business was, is in part because the purchasing entity wanted to keep you off the market. This is exactly what they were buying when they purchased the business. And so in those instances, non-comp agreements are a whole lot more enforceable than in the purely employment context. If you're a key person for the business, so if you have a really crucial management role, the non-comp agreement is going to likely be more enforceable than if you are someone lower down the line. And again, if you are a highly compensated individual, non-comp agreements tend to be more enforceable than if you are someone who is non-highly compensated. And all the time I get this follow-up question, which is, what does it mean to be highly compensated? I can't possibly tell you. It generally means that you make more than the judge does. And so if you make more than the judge does, then you're probably going to be considered highly compensated. And then there's a final reason that isn't precisely a legal reason, but nonetheless is an important reason to consider when you think about how enforceable is a non-comp agreement. And it's this. The company that is suing on the non-comp agreement can probably outspend you. And that means that if your departing employer is mad enough to do so, they can spend $20, $40, $50, $100,000 to ensure that the non-comp agreement gets enforced, as opposed to an individual who may or may not have the resources and may or may not have a new company that's willing to foot the bill for the legal defense costs. So that's some of the reasons why non-comp agreements may be more enforceable than you would think. And now I want to tell you why they might be less enforceable than you would otherwise think. And as I said at the beginning, I draft non-comp agreements all the time for companies. And when I do so, we draft them incredibly broadly as we can possibly think to draft them. If you're even thinking about competition while you're at your new employer, you're not allowed to do it. Well, those don't get enforced to that extent. As I've said at the beginning, the court looks at the agreement and says, look, we're not really going to enforce it in a way that is designed to squelch ordinary competition. We're only going to enforce it to the extent that it's designed to protect a legitimate business interest. And so the question is, if we as the lawyers who draft the agreements for companies know that the agreements won't be enforced to that extent, why do we do it anyway? And the answer is simple. We draft these agreements incredibly broadly because 50% of the time someone will look at the agreement and simply say, well, it says I can't do it, then I can't do it. It's a great reason for you to actually go to an employment lawyer and get some advice as to whether or not what you are thinking of doing would actually violate your non-competition agreement, despite how the agreement might be written. We draft these in a way that scares off 50% of the people from ever trying to challenge them. Your non-comp agreement may not be enforceable because what you are intending to do doesn't actually implicate any legitimate business interest of your former employer. So you might be going to a competing company, but working in an area in which you have no prior experience, or at least you had no protectable information. So you're not going to need to use the company's confidential or proprietary information. You're not going to be going after their clients or customers. You're working in an area in which is simply different from your old employer. Those are all reasons why the non-comp agreement may not be enforceable. Change of employer, the entity of your employer, and this is something that comes up a lot nowadays. You worked for a company that got bought out by a much larger company. Well, sometimes what the court says is, look, the fact that you signed a non-competition agreement when you worked for Joe's Stationery doesn't mean that that non-competition agreement should still be enforceable when Joe's Stationery is bought by Staples. And all of a sudden your non-competition agreement no longer covers you're competing with one small local mom-and-pop supply store, but a international chain of paper goods and office supplies. The change of your job, and this is an area in which we've seen courts more recently start to call into question whether or not a non-competition agreement will still be enforceable. And the idea is you signed a non-competition agreement when you had one position. You've been offered a very different position within the company. What the company should do at that point when you take your new job is have you sign a new non-competition agreement. A lot of them don't. That is not a guarantee that a promotion, for example, is going to void out your non-competition agreement. And a lot of the non-comp agreements are written to say, even if your position with us changes, this non-comp agreement remains in effect. And if they're written that way, the courts are more likely to honor that agreement. If you are a doctor or a lawyer, your non-comp agreement, if someone has tried to get you to sign one, is likely unenforceable for policy reasons. The idea is that the courts have said, and most states have statutes that say, The ability of a patient to select their doctor is so important that we are not going to allow non-competition agreements to interfere with that relationship. That ended up then getting extended to lawyer-client relationships, primarily because the lawyers write the laws. And so if the doctors weren't going to be affected by non-comps, the lawyers didn't want to be affected by non-comps either. And finally, your non-comp agreement may be less enforceable than you think if you live in California, in which case it's not enforceable at all. So with that in mind, I'm going to do a little bit of quick issue spotting, some of the most important issues that people should be looking out for when you are reviewing a non-comp agreement. The length of the agreement, obviously. The definition of competition, because this changes drastically from agreement to agreement. There are some companies that tailor their agreements very, very narrowly. This is our market, this is what we do, this is what you're going to be doing, that's what you're prohibited from competing in. Companies that do that do it because they know that it makes the non-comp agreement that much more enforceable. Some companies will say, we are looking to preclude you from working on anything that we do, anything that we might do, anything that we've contemplated doing, any client that we have, any client that is prospective. And so the range of what defines competition is really, really vastly different from agreement to agreement, and you need to pay attention to the language in your specific agreement. And as we already talked about, geographic scope is something that you should be looking for in the agreement to see, am I being precluded from doing this anywhere? Am I being precluded from doing this in the region, in the state, in the country? And how does that affect me in what I think I may do next? I always tell people, think about it, before you sign the agreement, and think about what your next move might be after the company you're about to join. Attorney's fees provisions. You really want to see, and I'm not telling you necessarily that you're going to have any ability to change these provisions, but they're things that you want to consider before you enter into the non-competition agreement. You want to think about, is there an attorney's fees provision in that non-comp agreement? Because I can promise you most of the time it's a one-way attorney's fees provision. And what it says is, if we, the company, have to hire a lawyer, bring a lawsuit, file for an injunction to enforce this non-competition agreement, and if we are successful at doing it, you owe us our legal fees, which means that in addition to having to pay your own lawyer, you may end up having to pay your former employer's attorney for their enforcement of the non-competition agreement. Look to the choice of law and jurisdiction provisions. They're sometimes combined, but they're two very different things. Choice of law means which state's law will apply to any disputes that you might have about the non-competition agreement. And the jurisdiction provision says, here's where you have to bring the lawsuit, or here's where you are agreeing to be sued. And this is an important consideration because you may be working in Massachusetts for a national employer that's headquartered in Florida. And if the non-competition agreement says you are agreeing to jurisdiction in the state and federal courts of Florida, then all of a sudden when you are being sued or having to challenge the non-comp agreement, you're not going to be able to do so in Massachusetts. You're going to be doing so in Florida, where you have to find a lawyer, show up for depositions, show up for court hearings sometimes. It adds to the expense in your challenging the non-competition agreement. Look to see if the agreement has an arbitration clause. It's not that I am anti-arbitration by any means. It's just something that you need to know about. A lot of non-competition agreements include provisions that say if there's any dispute over the scope scope of this non-competition agreement, it gets decided by an arbitrator. That means you don't have a judge and you don't have a jury. You are in private arbitration somewhere. It tends to be a bit faster sometimes. It can be less expensive sometimes, but it does mean that you are giving up your right to have your case decided by a judge or a jury. Another very important issue to look for in a non-competition agreement is very often companies will tie, if you have a severance provision or if you have equity in the company or stock options or employee stock, a lot of times those things can be tied to the non-competition agreement. And so the company will say, if you violate the non-competition agreement, you forfeit any severance that you might have received under the severance agreement, or you forfeit your right to the stock or the stock options. Those are things that can be enforced. They're important to know that they're in the agreement when you're making your considerations as to whether or not it's something that you're willing to sign. And the last category that I'm going to go over, and then we'll open it up to some questions, some easy ways to stay out of trouble in general when you are leaving a company. Number one is don't take anything with you. And I tell people this all the time. Walk out with empty pockets. You will increase your odds of getting sued and being successfully sued if you leave with confidential or proprietary information of the company. The assumption is going to be that you intend to use that information at a new employer. I tell people this all the time. People say to me all the time, I understand, and then they plug a thumb drive into their computer and download tons of information. And when you talk to them about, well, why did you do that? Did you not understand, leave with nothing in your pockets? Everyone always has an explanation. Oh, well, I wanted my form files, I wanted my documents, I wanted this information. That's the kind of thing that computer forensics firms will find out that someone has done and will end up making your non-competition agreement much, much more enforceable. The court will assume that you intended to do something bad with that information. My next note says, don't be overtly stupid. And when I wrote that, I had something in particular in mind for a case that I'm dealing with right now where the employee who left within 1 hour of having left the offices had changed his LinkedIn page to show that he was going not only to a direct competitor, but that he was taking a directly competitive job doing precisely what he had done for the original employer, although he had told the original employer that he was going to be doing something completely different. That screen grab was instrumental in convincing the new employer that they had made a mistake in hiring him, and they decided to not go forward with the hiring of that individual. Don't lie on your way out. People all the time say, well, I'm going to tell them that I'm going to one place even though I'm going to another place. They'll never figure it out. They always figure it out. You end up at a trade show. You end up talking to people that are that you think are friendly to your side of the story, who turn around and tell the former employer. We always figure it out. It's not worth it to lie on your way out, not simply because it gets figured out, but because then the first thing that gets said in court is the person knew that what they were doing was wrong. How do we know that? When they were asked by the former employer, they lied about where they were going. The only reason for them to lie about where they were going and what they were doing is they knew it was going to violate the non-competition agreement. And finally, on my list of things of how to stay out of trouble, don't try and be overly clever. Almost all the time, I get people who come in with incredibly complex schemes about how they're going to hide the fact that they are violating their non-comp. well, I'm going to create this new company, but the company's not going to be in my name. It's going to be in my girlfriend's name. No one's ever going to figure it out. And again, we almost always figure it out. Those complex scenarios in which you've created shell companies with various names, or you're trying some other complicated way to hide the fact that you are violating a non-comp, they almost never work. It is a great way to get yourself in more trouble as opposed to out of trouble. And so those are my, that's what I've got, and let's open it up, I guess, to any questions that people might have.
Great. Thank you so much, Evan. I, for one, really learned a lot. I have a lot of questions here, so bear with sort of siphon through. It seems that one sort of thematic question was going back to sort of the moving from state to state. So you're in California and you move to New Jersey, or you're in New Jersey and you're moving to California. How do you sort of protect yourself? What holds up where? Can you just dive maybe a little more into that of explanation of state to state, where one maybe it's not as enforceable, where others it would be?
Yes, and it is a question that comes up a lot. So if you are in Massachusetts and you have a non-comp with a Massachusetts company and you're now moving to California for the next job, can the first company enforce the non-comp agreement against you since California won't honor the agreement? Well, it becomes a really, really complicated question. First of all, if the first company drafted the agreement correctly, then they've said that Massachusetts law is going to apply and that any disputes need to get decided in Massachusetts. Now, let's assume that they've done that correctly. It's still not the end of the inquiry. It becomes, to an extent, how much risk tolerance you have, because a person can move to California and say, hey, go ahead and do whatever you're going to do. You can't really reach me here in California because the California courts aren't going to enforce it, even if you were to get a decision in Massachusetts. I don't really recommend it. If you were originally in a state where the non-comp agreement was enforceable, you may have some leverage in negotiating when you move to California, but unless you're never planning on coming back and you're never planning on having a bank account that could be attached in Massachusetts, and your new employer is really, really confident that they can't have any assets attached in Massachusetts, then I would tell you there's still a risk. In the other direction, if you were originally employed in California by a California corporation, the odds are pretty good that your agreement doesn't have a non-comp provision in it. I've known some California companies think that they're being clever by saying, we're going to apply Massachusetts law, even though you are a California employee. Tends to not work in that direction. So if your original employment was in California and you've moved somewhere else, you're probably okay. If you were in some state where non-comps are enforceable and you're moving to California, it becomes a bit more tricky.
Great. What's the penalty for having a non-comp agreement enforced successfully against you? Okay.
So there are a number of potential outcomes here. The first outcome, and the one that people are generally the most fearful of, is that what the company will do, and what I do for companies, is we go into court immediately and ask for what's called a preliminary injunction. We say to the court, unless you enforce this non-competition agreement right now, by the time the case is over, the whole thing will be moot. The damage will have been done. And so the first fear that people have is by enforcing the non-competition agreement, the court will actively say to the new employer, you cannot employ this person, period. And so now you've left your prior job, you've moved to what you think is your new dream job, and the court has told you you cannot take that job, you cannot continue to work for that employer. It does happen. Another variation on that theme is that the new employer says, oh my goodness, we didn't know that we were about to be in for this fight. We're sorry, we're just going to revoke the offer. That also happens a lot. If it doesn't happen, the penalty for violation of the non-comp agreement can vary. One of the things that people can be on the hook for is you've gone to a new company and the former employer loses customers or clients because of your move. Well, any profits that the new company sees as a result of that, or any profits that the old company has lost, can be some of the damages that are recoverable. If the non-comp was in connection with the sale of a business, they can look for some or all of the purchase price of the business back. So the damages really can be significant. And again, as I've said, if there is an attorney's fees provision in the agreement as well, you may be looking at paying the other side's legal fees as well as your own.
Great. What's the typical length of time for a non-compete agreement?
It varies industry to industry. And so in high tech, the time frames are generally shorter because it is considered that the information that you have in high tech is valuable for a shorter period of time because the industry changes so quickly. In high tech, I see non-comps that range from 6 months at the low end to about 2 years on the real high end, though 1 year is more typical. Outside of high tech, they generally start at 1 year and they'll run up to 2 years. And as I said, with sales of businesses, you'll see them run up to 5.
Great. And what about fees? How much money might you expect to have to pay an attorney to look at your documents if you're wise enough to have somebody do that before you sign something?
Okay. So if you're having someone, and I really tell people, please do, it's worth it in the short term. If you're having someone look at your agreement, you're generally talking only a few hours. And so I would say look to spend $1,000 to $2,000 to review the agreement, to have an in-depth discussion about the agreement, sometimes and it's not frequently the case, certainly not with larger employers, that you might necessarily be able to negotiate the terms. But I will tell you, with smaller employers, you sometimes can negotiate the terms, including carve-outs for certain areas or certain companies that you might think that you're going to afterwards. $1,000 or $2,000 as an upfront investment really tends to be worth it later down the line when you are looking to make the switch.
Okay. And some people have commented that when you are you're offered a job, the employer has all the power. The employer comes to you with all of these documents. You really want the job. They come to you and they say, here, this is our agreement. Everybody signs it. This is what everybody does. And you're looking at it and you're realizing you're sort of signing your life away. How can you be smart? What are the things that are reasonable to ask for when you are intimidated by looking at this document? What's doable? How can you be savvy? What are the sort of things that right off the bat you should notice and then seek some professional advice about? What are the real red flags in those documents?
Okay. And again, it is hard to negotiate, and it is hard necessarily, a lot of companies will say, look, this is our non-comp and it's take it or leave it. And what I say to people is, think about right now how much you do want this job. It may be your dream job, and you may decide, you know what, no matter what happens from here on in, I'm willing to accept it because this is the job that I want. But think long and hard about that. Think about whether it is worth it to be told that you are going to be taken off the market or out of this particular area for a couple of years. However, again, some of the areas that you can sometimes nibble away at the edges are things like the attorney's fees provision. Well, the company may not be willing to take out an attorney's fees provision, but they might be willing to make it reciprocal. So instead of simply saying that the company will get their attorney's fees if they're successful, why not have a provision that says that whoever the prevailing party is entitled to their attorney's fees? Companies will sometimes allow you to negotiate smaller geographic locations. They'll sometimes allow people to negotiate down the time of the duration of the agreement. Sometimes what you'll say is, look, I'm coming here and I'm going to be building out this specific kind of software for you. I don't want to be precluded from building any other kind of software if it doesn't compete with what I'm doing here. Let's make the definition of competition a bit more specific. Or sometimes it's a question of, can we build into the agreement the names of the 10 companies who you consider to be the direct competitors? Those are the kind of things that you can sometimes do. Sometimes that you can also negotiate on the other end of things. And I very often, I do this from both sides, and I very often find that if we are sort of upfront with the old employer and say, look, here's what the person is going to do. We are willing to make sure that for the entire term of the non-competition agreement, that the person isn't going to be soliciting any customer or client with whom he or she had significant contact while they were employed at the old company. And that's what you're really worried about. I mean, the question that you end up asking is, what is the old company really worried about? Sometimes the old company is kind of reasonable, and they'll say to you, look, all we're really concerned about is we don't want you poaching our customers or clients. We don't want you poaching our employees. We don't want you using the information that you have. And if that's the case, it's something that you might be able to negotiate. Honestly, though, sometimes you have employers who say, look, we don't care if you are going and saying that you're going to be doing something else. We fight everyone on our non-competition agreements because we want to make sure that people don't violate them. There are companies with reputations that they will sue every employee who leaves and goes to someone that they think is even vaguely competitive, and their concern is not necessarily whether or not they win. It's sending a message to everyone else not to try it. So hopefully that answers the question.
Is there a statute of limitations on non-comp agreements?
Not in the way that people think. It is a contract, and the general statute of limitations for contracts, although again varies state by state, but the general statute of limitations is 6 years. But when you're talking about non-competition agreements, you're generally not really talking about a statute of limitations issue. What you are talking about is, first, what's the duration of the agreement? Is it a 6-month agreement? Is it a 1-year agreement? And look, this is another interesting point. If the company has drafted the agreement well, it will have a provision that says, if you violate the non-competition agreement, the non-competition agreement will automatically be extended for the amount of time that you were in violation. And so, if the agreement said that it was for 6 months, but they found out that you were violating it for 3 months, well, then it gets extended for another 3 months. What generally happens, though, and the reason that statute of limitations really don't apply as much in non-comp contexts, is that as soon as the company figures out that someone is really doing something that they're worried about, you will get a demand letter and or lawsuit filed almost immediately. And the reason for that is there's a real danger to the former employer. If they delay, it's a great argument for the other side that they're really not worried about some legitimate business interest. Because when we are worried about a legitimate business interest, we sue right away. We either sue We write a demand letter, we notify the new employer, but these things happen really quickly as compared to other cases where someone might wait 6 months or a year before bringing suit.
Are there differences in non-comp agreements if you are a contractor or 1099 or you're a consultant or you're only being hired for a 6-month period? Are there differences, or are there more sort of pitfalls for individuals in those categories?
There are some differences, and I'll start by saying that independent contractor agreements are something that we could spend another hour talking about, particularly in Massachusetts, where we have what I think to be the most stringent independent contractor law in the country. It's much more restrictive than the IRS test. It's much more restrictive than about any other state, and almost anyone who is operating under an independent contractor agreement in Massachusetts, and I'm not going to say everyone, but almost everyone who's operating under an independent contractor agreement has been misclassified as an independent contractor, and the government would consider them to actually be an employee. Now, the nice thing about that for individuals is that it gives you a point of leverage that you may not have otherwise had. And so when the company looks to enforce the non-competition agreement, your ability to go back and say, oh, well, that's nice. You may want to enforce the non-competition agreement, but guess what? My counterclaims are going to be for misclassification, which is going to have all sorts of implications for the former employer if the misclassification is really a misclassification. Now, that having been said, can there be non-comp agreements for independent contractors? Yes, there can. They tend to be subject to the same sort of restrictions. They really have to be protecting a legitimate business interest. The shorter the duration of your employment, the less that it is going to be seen that you are, that the company is trying to protect a legitimate business interest. That being said, I have seen companies that that give non-comp agreements to their summer interns. I find it to be, unless they're incredibly narrowly drawn, I find it to be a bit absurd. The courts tend to find them to be a bit absurd, but it's not like there aren't companies out there that are doing it.
Have you ever seen circumstances with ramp-up non-comps that scales in length over duration of time at a company?
You know, it's an interesting question. I have not precisely seen companies that have a ramp-up. More frequently what happens is someone is hired, they're hired at a certain level, and they may have no non-comp, or the non-comp that they have may be of a short duration commensurate with the level that they're at within the company. And then when they are given more responsibility and exposed to more of the company's confidential and proprietary information, the company has them sign a new non-comp that expands the coverage, the duration, the consequences. Very often, when people are granted stock, the non-comp will ramp up. So it's not that it's built into the original agreement usually, but it's that when people advance through the company, both with job responsibility, with the information that's given to them, with the compensation that's given to them, that they're asked to sign new, more restrictive non-comp agreements.
I'm not sure I completely understand this question, but maybe you'll get it from the way the person wrote it. Do non-competes between companies follow the same rules as non-competes between a company and an employee? An example of this is a person that starts a consulting company that does work for a client. The non-compete would be between the two firms and not between the client and the consultant.
Yeah, and I do understand the question, and it's something that we deal with frequently. And the answer is, unfortunately, the answer to a lot in non-comp law is it depends. The courts will look at those agreements, and honestly, they will give a little more scrutiny to the question of whether or not what we are looking at here could constitute an antitrust violation. And so, for example, one of the agreements that came under scrutiny recently were all of the computer companies trying to enter into agreements that talked about not poaching each other's employees, and that was seen to be more anti-competitive. To the extent that we're simply talking about a company that engages a consulting company, and it's usually a company that really has a few consultants, and they're looking to have a non-competition provision in there, they get enforced largely to the same extent as they do when it is with a employee or an independent contractor. And so they remain enforceable, but they remain enforceable to the extent that they're designed to protect legitimate business interests.
Great. I think I have exhausted our questions. There are lots of duplicates. This has been fascinating for me. Evan, thank you so much for your time. I know that there's have expressed an interest in wanting to reach out to you, perhaps professionally, for some advice. Obviously, I'm sure that comes with a fee structure, obviously, but I think that we certainly value the time that you've given us today. I'm hoping that people are welcome to contact you through your firm.
Yeah, absolutely. That would be great.
Thank you again for your time. And
thank you, everyone.
On behalf of the MIT Alumni Association, thank you, and have a wonderful afternoon, everyone.
Thank you.
Bye-bye.